We will go on the record in the matter 25 CF 54, State of Wisconsin versus Zachary Chaffy. The state appears through District Attorney Kevin Schmidt in person. Mr. Chaffy appears in person with his counsel, Shirlene Perrin. He is also in custody. We're set today in this matter for the sentencing portion of this case. Mr. Chaffy pled guilty to manufacturing, delivering designer drugs less than 3 grams, a class F.
Okay, right away, this case sounds like your standard drug lab sentencing. Until you realize the substance at the center of it all is DMT psychedelic so unusual. Even the judge admits later she had to research it herself. And trust me, that changes the entire tone of this hearing. This isn't your typical meth lab prosecution. The court is about to enter a very weird legal gray area.
Felony as a party to a crime, maintaining a drug trafficking place, an I felony as a party to a crime. The court ordered pre-sentence investigation report. The court has received and reviewed that report. Defense ordered an alternative pre-sentence investigation report. The court has received and reviewed that report. Nothing significant stood out to the court as being a mistake, but Mr. Schmidt, did you receive copies of both of those reports?
I received them, reviewed them. I don't have corrections per se. I'll disagree with facts.
Okay. Or we lost power apparently.
Sorry.
Again.
Did you hear me for that? I need to say again. Okay.
All right. Ms. Perrin, did you receive both reports?
Yes.
And do you have any corrections or material alterations that need to be, or modifications that need to be stated on the record?
No.
All right. Then we can proceed with sentencing and recommendation. Mr. Schmidt.
Thank you. State's going to be arguing for 2 and 6 out on the manufacture and 1.5 and 2 out on the maintaining a drug trafficking house. The reason for the difference in the state's recommendations in this case versus the one with Chamberlain is based purely on the criminal history. You can see from Chaffy's criminal history that because of his interactions with the criminal justice system, that he has more reason to know better. He's been to prison before. He's a felon, so he knows he shouldn't be around firearms. That being said, the reason for the discrepancy between the state's recommendation and DOC's recommendation comes more from DOC's summary and conclusion section. DOC made a number of assumptions that are mistaken, which I'm sure the court probably already caught since we did Laura Chamberlain's sentencing and I already pointed these things out. First, DOC assumes that these convictions or this evidence is indicative that Chamberlain and Chaffy were distributing DMT, dimethyltryptamine, into the community. The second mistaken premise is that DOC had indicated they believed the substance was dangerous and addictive. We know this because in their basis for recommendation on page 24, they wrote that as part of why they gave the higher recommendation, they believed that this behavior contributed directly to the increase of illegal drugs in the community and created an unsafe environment that promoted cycles of addiction and harm in the community. And the second thing they indicated was that they believed that this substance, dimethyltryptamine, is dangerous and addictive, same page. So first of all, I'm going to briefly describe the facts of this case as they all played out. Police came to search the old bank in Grantsburg sometime after the property was transferred through a divorce proceeding between Laura Chamberlain and her ex-husband. She was living with and allegedly renting space to her boyfriend, Zachary Chaffy, in the same building. Per records of the family court case, big part of the fight between the Chamberlains was about some firearms that belonged to the husband. I guess they had custom features, so there were a lot of visits for assessors to look at the firearms in this place, and Zachary Chaffy was present. When we were doing the motion based upon the motion in this case, the state collected a lot of the family court documents. So it was well known for a long time these guns were there, and so was Zachary Chaffy. The ex-husband, when he seized property on the order of the Polk County Court, found a number of suspicious items, including what he believed was some sort of lab. He asked the sheriff's office deputies to look at it. In our area, we have a lot of methamphetamine. We have past experience with methamphetamine labs. We have experts on what methamphetamine labs look like. They looked at it. They said, this is not a methamphetamine lab. And it was just left to be. Later on, a Grantsburg Police Department officer had occasion to look at the lab, and she, along with a different deputy, caused the pictures to be sent to the Department of Criminal Investigation. They quickly recognized it as equipment to create dimethyltryptamine. They also said that there are some chemicals there that could be used to create the Cold War era poison ricin favored by the Soviet Union, which is kind of an oddity. Police executed a warrant based on the information. As soon as they checked the lab, got in, and weren't just working off of photos, that is, once the clear team with the experts got in and looked at it, they quickly saw like it didn't have the other components to make ricin. You can make a lot of different things with a lot of chemicals, so they don't think they're making ricin there.
Now, this is where the case takes a sharp turn. Investigators initially feared they'd uncovered a dangerous chemical operation, only to realize the lab wasn't explosive, wasn't toxic in the traditional sense, and apparently wasn't even producing a final sellable product. Translation: the prosecution suddenly has to walk a tightrope, punish illegal manufacturing without exaggerating the actual danger, and in sentencing hearings, that distinction matters a lot.
They also confirmed it was a dimethyltryptamine lab, and the way the lab is going and the way dimethyltryptamine is created, it is not a dangerous type of lab. So they removed the PPE before they even started removing the equipment from there. Big difference between methamphetamine labs and dimethyltryptamine labs is methamphetamine labs involve substances that gather energy even in the air so they can become explosive. They also involve chemicals that can very easily scatter and be corrosive and contaminate the environment. Big difference with DMT, where the biggest danger of the lab is that inherent with using a pressure cooker, and you use a really basic substance at one point in the manufacture. Basic in terms of the opposite of acidic. That being said, all the chemicals and substances we found that were used in the creation of it were substances you can just buy legally. DCI believed the substance they found in the jars that formed the basis for the offense, this biphase substance in these jars, was DMT in its final stages. State lab confirmed it is DMT, dimethyltryptamine. DCI was surprised that the one thing they didn't find is some of the equipment for like one last step that would have involved creating it, really condensing into like a crystal form, and we never found any final product of it. We also did not find large amounts of cash on it. That is, the jars that were found were the final stage of making it. To this day, no law enforcement in Burnett County has actually found somebody possessing dimethyltryptamine. Nobody in law enforcement knew what it was before we found it here in this case. The way the Department of Criminal Investigations originally described it as a designer drug, and they said it was used as like a party drug where people abuse it. They said that basically it causes a psychedelic trip akin to mushrooms that is more controlled, lasts in short bursts, more like 15 to 20 minutes. In her allocution, Laura Chamberlain admitted they were making dimethyltryptamine, but said it was for personal use. She said they were kind of experimenting with it. This is echoed in Chaffy's statement to the PSI writer. He says something very similar. Chamberlain's explanation of them kind of just looking up online and ordering the materials and trying their hand at it helps explain why some of the equipment for the very final step was missing. They probably just didn't know, and also explains why it ended in this last phase before the final pull. That is why you'd have so many of these jars and not pull the final product off of it, because they thought they didn't successfully complete it. We heard that from Laura Chamberlain. So that actually helped explain some of the evidence, I thought, in a way that I thought was pretty compelling. In preparation for this case, when it's set for trial, the state conducted its own research and further consulted with DCI, because doing the trial would necessarily require explaining how do you generally make dimethyltryptamine and how each piece of equipment and chemical in this lab would be used to do it. And also for sentencing eventually, since I knew this court wasn't familiar with dimethyltryptamine, what are the risks associated with it? How dangerous is it? We treat different substances differently. The way we sentence THC is different from meth, is different from fentanyl. And that is when conferring with DCI, the state discovered that DMT is extremely easy to be made. It naturally exists in nature. Really what you do is you concentrate it through a different process. As also when the state came upon Gonzalez v. O Centro Espirita Beneficiente União do Vegetal, which is 546 US 418, Perrin 2006, and Perrin.
When you're done, can you please make sure that the spelling is to the court reporter?
I will. That was the 2006 Supreme Court of the United States case, which dealt with whether the government could just blanket ban dimethyltryptamine through the Controlled Substances Act. The lower courts found that because it had a long tradition of use in cultural and tribal practices and was being used in the southern United States for religious practices, that is, as part of sacrament for some churches, for the government to be able to ban it, you have to do rational basis review, which involved weighing the pros and cons of the substance. The lower courts found that the pros and cons of the substance were equal. That is, it's a substance that naturally occurs. It's not addictive. It doesn't have a high risk of overdose unless you mix it with other things. The highest health consequence is really someone having a bad trip or more physically, just high blood pressure. As a result, the Supreme Court of the United States adopted those courts' position and found that you can't just flat ban it. You can have religious exemption and possibly others. It's kind of treated the same as how peyote can be treated. I bring that up because it helps demonstrate that the Supreme Court of the United States has actually made factual findings about the level of dangerousness of the substance, the addictive nature of it, which is not high. That's why we don't see it in the area.
Did you catch what just happened there? The prosecutor is basically arguing against the harsher assumptions in the official corrections report. That's rare. Usually prosecutors lean into maximum danger narratives, but here the state is practically saying, look, this wasn't Breaking Bad. Instead of painting Chaffy as a cartel mastermind, they're framing him as a reckless experimenter with a chemistry hobby and internet access, honestly. Probably one of the most unusual sentencing arguments you'll ever hear.
Just not chemically addictive like other substances are. So this is how I think the court should view the case and why I summarize those facts. This is two people who created, using some pretty mundane equipment with substances they ordered online, instructions they likely found online, to create dimethyltryptamine, and they did so. There's no evidence they distributed it to the community. Manufacture of a controlled substance does not require proving that, and the state had no intention of arguing that when it charged it. What they pled guilty to then, that manufacture of a controlled substance and the maintaining a drug trafficking house, that's how those offenses should be viewed and why we're not arguing for a larger sentence than the 2 years initial confinement on this. That is, a person manufacturing or creating something for themselves, whether it's growing weed or condensing down dimethyltryptamine out of bark into a more concentrated form for themselves, is different than someone who, as the PSI writer indicates, would be a problem, someone who's distributing it to the community. And we have no evidence of that here. So that's why I summarized those facts and wanted to address what some of the things DOC wrote there, because I think that the Department of Corrections viewed this how they view other substances that they maybe understand better, and other labs that they understand better. We use our local writers for these, and we know that methamphetamine labs are very dangerous, and this is not a methamphetamine lab. That being said, I do think that this small amount of prison is necessary because of the history of Mr. Chaffy, because he's been to prison in the past, and because, you know, we can show through forensics that he touched something within one of the guns. I believe his fingerprint was on one of the casings. That, and just in general, he was present and those guns were pretty openly stored there during the course of the divorce. And the guns there with the presence of the other items is concerning. What the state's goal would be with the 2 and 6, or the sentence suggested today, being asked of the court today, is there would be a punishment component with the 2 years initial confinement. The extended supervision component is important just to make sure he doesn't do it again. Ironically, because the state lab tested it, they now know that this process does work. It does create DMT, and they could just do what they did before and just do one extra step and be able to have it in the concentrated form. So having that supervision to just make sure that doesn't happen and make sure there's treatment and dealing with the mindset that leads into wanting to create an experiment with this substance would go a long way to preventing it in the future. Thank you.
Thank you. Ms. Perrin.
Thank you, Your Honor. Upon reviewing the history of Mr. Chaffy, it's he doesn't have the worst criminal history. There's some minor, there's serious issues, but they're not felonies. The DUIs and some of the other issues are misdemeanors. They're indicative, however, of substance abuse issues. And I think that comes out clearly in the alternative sentencing report. Mr. Rooney did an evaluation also with that report that demonstrates a need for treatment. We would ask the court to make him eligible for earned release because of that. And Mr. Chaffy would ask the court for a lower sentence than either report request and from the prosecution. He would ask for a year sentence. He's been in custody for almost exactly a year. Haven't quite added that up. It looks like his initial appearance was on May 7th.
Arrested on April 23rd, 2025.
April 23rd. And so that is the sentence he asked for. He states that he had a pretty good childhood. He's got some education beyond high school. He has some skills as far as work skills. Mr. Chaffy has potential to support himself and his children when he's out in the community, and he has potential to contribute in the community in a significant way. And so we ask the court to consider all of those issues and everything that the prosecution said and sentence him accordingly. Thank you.
Thank you. So what is happening with his conviction from Cerro Gordo County, Iowa? From November 6, 2024, Dominion control of a firearm. He was sentenced to 5 years of prison with 3 years of state probation. But has that been affected by this case?
Not that I'm aware of.
Do they even know about this case?
Yes, they do.
Yes.
And are you just waiting to hear from them if there are other steps?
From Your Honor, from what I've gathered is that my probation officer in Minnesota said that he wasn't sure what they'd want to do, but since I hadn't had any other issues on probation, so he just told me that if I was released, that I needed to see him within 72 hours.
So wait and see. We'll see what happens approach, huh?
Yeah. So I don't know if they'll give me a violation and then the time I sat counts towards a violation, or what they wanted to do.
Because that's a serious case and a serious sentence. And then the other prison sentence with the assault, second-degree dangerous weapons, that was your first really serious conviction.
Yes, Your Honor.
And that's where you went to prison. Mr. Chaffy, is there anything you want to tell me, you want to let me know as it relates to this matter, to your history, to your criminal record? Tell me a little bit more about that whole Iowa matter and case, and because that seems like a harsh sentence. I don't know anything about the Iowa justice system, to be
Yeah. I honestly, I don't know anything about the Iowa criminal justice system really either. We were traveling through town and got pulled over. there was a couple, Miss Chamberlain's guns were on the bike, and we got taken in. They gave me, I sat in jail down there for, I don't know, 17 days or something, and they offered me a plea deal, and I took the plea deal. They, 3 years probation. I think I got a year left of that probation.
Oh, wow. That was quick. Offense date, August 31st, 2024. Conviction date, November 6th, 2024. Quick turnaround.
Yep.
So Miss Chamberlain was with you at that time?
Yes,
Was she arrested?
I believe so.
And she wasn't convicted of anything?
Not that I'm aware of.
Not that I was aware of, or I would have seen it in the PSI, but I did not. What else do you want me to know?
I had a good upbringing.
This next section is critical because the judge shifts from legal analysis into character analysis. Sentencing hearings aren't just about what happened, they're about who the defendant is. Notice how the court starts probing his past relationships, parenting, alcohol abuse, prior convictions. All of that feeds into one giant question: is this someone who can realistically be rehabilitated? Because once a judge believes the answer is yes, the sentencing math changes dramatically.
I grew up on a farm. I got a good work ethic. After my first divorce, when I was getting a divorce and my first wife left me, I fell off pretty hard. I started drinking heavily, trying to kill some of the pain and anguish of my wife leaving me, I guess. Ended up getting into a bar fight in the cities, and that's when I got my first major charge. I owned up to it right away and did my time. I just, I don't know, I got kids. It was my little boy's birthday on Wednesday. He just turned 6. So it was sad not being there for him. But
I know, but I just have to throw in, you have like 2 other kids, but you're not with them. You don't do any, you haven't seen them in years.
yeah, that was due to my first divorce. I've actually taken my ex-wife back to court like 20 sometimes trying to see him, and she just won't abide by any of what the court says. So I guess my youngest boy, I've just been really adamant to be there for him all the time. Just trying to do my best. I understand I screwed up, and I just want to do better for myself, for my kids.
All right, anything else?
No, Your Honor.
Well, I have reviewed these reports thoroughly. And I, as well as Mr. Schmidt, realized that when I got the recommendation back from on the PSI, I was a bit taken aback by the recommendation. It was pretty high. 4 to 5 years in, 2 to 3 years out. But I'm going to tell you the recommendation for Iowa, that's pretty high too, especially if I take you for your word that you were driving on a motorcycle, riding on a motorcycle, and you had Miss Chamberlain's guns. Doesn't mean you're still there. You're still present. You can still own and possess and touch those guns. It's still illegal. That's 5 years in prison. Granted, it's imposed but stayed, but that seems pretty high. Did you agree to a deal with that?
Yes, Your Honor. I took a plea deal to get out of jail right away.
Mr. Schmidt is right that the court wasn't familiar with DMT and what exactly that was prior to this case. But I'm going to tell you, I hear it now when you watch some shows and they're in some clubs and you hear somebody say, "Hey, can I have some of that DMT?" Oh, my ears perk up because now I know what it is.
I guess I was more curious because I started learning more about the native ways and the rituals for like down in South America, Mexico, and it's even in the lower states. I got really curious about it because I wanted to learn more about my conscious mind and our state of being in this physical realm we're in. And it was something that was short-lived. It didn't seem like it was, something that, like you get some bad acid and fries people for their life, where this seemed pretty benign to me. Like, try it if I'd, maybe experience a different plane of existence. that we live in, that we're all here, for a couple minutes. It was, just thought I would try to open my mind more, since I'm not really a religious person. I've dabbled in most religions, tried to find where I fit in on this planet we live on. I didn't really find it in, Jesus and, the Baptist or Christian church. I grew up Baptist, and something just seemed off to me. So I just really wanted to, understand more about why we're here, and do we go someplace else? Is there another realm that we live in, or is this it? It really piqued my curiosity about, our physical being against our spiritual beings, I guess. And that was one of the things that they said would connect you more to your spiritual side of things than anything. And it piqued my curiosity into psychedelics a little bit. And I guess
I hear you. I mean, I can kind of believe you in some respects. But
and they're doing all sorts of studies now nationwide with psychedelics and dealing with past traumas and
correct, but taking hallucinogenics and to have psychedelic experiences really isn't going to tell you why we're here or how the earth is formed or all of those things. It's just going to give you that illusion of something that really isn't existing. It's just going to give you a high for 15 to 20 minutes. Granted, there may not be a lot of negative effects. There are some, because in the research that I've done with DMT, that yes, it can cause some health issues. It could actually cause somebody to go into a coma if they take too much of it, they take a wrong dose. You could actually have a bad trip, and you could do something terrible because you are not in control of your body. You do not have an idea of what's going on. So I strongly recommend that if that is a venture that you want to take, you go do it with people who know how to do it, or who have been doing it, like the Native American tribes, or or whatever tribes are experimenting or have been using this for years and years and years. Don't try and make it on your own. Especially don't try and make it here in Burnett County. That was the dumbest move.
Yes, Your Honor.
You can actually feel the courtroom dynamic changing here. The judge clearly thinks this was incredibly stupid, but not necessarily evil, and that distinction is huge. She's basically saying, I believe you were searching for meaning, but you chose one of the dumbest possible ways to do it. Also, can we acknowledge how surreal it is to hear a judge casually recommend someone travel internationally for psychedelic experiences instead of manufacturing DMT in Wisconsin? This sentencing hearing officially left planet Earth about 10 minutes ago.
You seem like a likable guy. I mean, Miss Chamberlain, I don't know your last name, that is said in here, and I'm like, who is this lady? Thought you had another girlfriend and I was confused. But from the things that she has said about you, and from what I read there, other than not having contact with your other kids, which you should still try and rebuild that relationship, they're still pretty young. You do seem like a likable guy. You seem like you like to work hard, and you want to be there for your one son. You want to provide. You've had a handy business for years. You did a really stupid thing. A really stupid thing. And again, I understand that a DMT lab is completely different than a methamphetamine lab, that perhaps a DMT lab has very little chance of exploding or doing any of those things like a meth lab does. But did you know that when you were constructing your lab?
I had done quite an extensive research into it to know that it was pretty harmless. I knew there was no chance really of it exploding in my face like other labs do. And it was pretty much just to mix stuff together in a jar and mix it up. And that's, so it seemed like it pretty,
And reviewing the reports, they pretty much have very similar information, just different recommendations. Some tweaks here or there based upon the report. It's interesting how the alternative PSI comes back and says 2 years in and 2.5 years of extended supervision, which is kind of in line with, I believe, the original agreement that was reached between the parties, which is argued, well, was that an agreement or was it free to argue for defense? Because they did argue for something different.
I followed the agreement.
So defense didn't. But neither here nor there. It's pretty much in line with what the agreement was to begin with. I have to look at the nature and the gravity of the offense, and here, perhaps this wasn't the most serious drug, most dangerous drug. I'm going to tell you, we have prescription drugs that are more addictive and more harmful and cause a whole lot more ill and bad effects and harm our community more than perhaps DMT. The serious part of this is the fact that you became your own chemist and wanted to make this, and you wanted to make this in our county. Because what does that show other people? Hey, I found about this hallucinogenic substance that from Africa, and I can do this, and all I have to do is order these supplies because we can get our hands on everything now today, everything. And so what's going to stop another person from trying to have their own lab to create their own thing to do all of these things? That's the serious part here, is the fact that you became a person who was manufacturing an illegal substance, a Schedule I legal substance. And in looking at you, you have the criminal history, you have the prison sentence, you've been to prison, you have the one hanging over your head. You're doing some dumb things that could ruin the rest of your life. If you want to be with Miss Chamberlain and she wants to be with you, it was very adamant she wants to continue to be with you. And if that's the case, Miss Chamberlain, don't own any guns, okay? Because you're just going to send him to prison, all right? Doesn't matter if they're locked up or they're not locked up. And in this case, his fingerprints were on some of I forget if it was the casing or the gun or whatever, but no guns. You can't, you're a felon. And that's the serious thing too, is to look at that. And I understand the argument that they were Miss Chamberlain's husbands, just kind of hanging out there, but not in the Iowa case. They weren't. And you knew that. They're probably in the saddlebag or probably in the little compartment on the motorcycle. I have to look at needing to protect the public, as well as deterrence, deterring you from continuing to do these dumb, stupid things. Don't. Why continue to risk your life and risk the relationship that you have with your children or your child and the potential that you could have with your other children? It's not too late. Don't be a deadbeat dad, because that's what they feel. I've known people who have had a father who hasn't been present or has been there for one time, and then 6 years later they pop in, and that's what they feel. Don't be that. Don't let that happen. Don't let your children's mothers do that to you nor to your children. They deserve better. I want to give you a chance because I do believe that you have an ability to rehabilitate. I believe that this year has definitely hit you pretty hard. I do think that this is a prison sentence for all of the reasons that have been stated and argued, and the fact that I do have, all people argue for a prison sentence, just differing levels, and the courts argue for a prison sentence, just differing levels. Mr. Chaffy, I really, truly don't want you to let the court down, because I'm going to believe in you. I don't want you to let the community down. But
All right, final prediction time. The prosecution asked for prison. The defense pushed for essentially time served. But listen carefully to the judge's language. She keeps repeating words like potential, rehabilitation, and chance that usually signals a sentence lower than the prosecution requested, but with strict supervision attached. In other words, I'm giving you an opportunity, don't make me regret it. And honestly, those are sometimes the most consequential sentences of all.
I'm going to sentence you to 1.5 years of initial confinement for each, concurrent to each other. I'm going to order five years of extended supervision on the first count, 2 years on the second count, or on the other count. I'm only doing 5. I was going to do less, but you're still going to be on the Iowa supervision and probation. So they'll run concurrently together. And the fact is because if you're going to mess up, then you're going to go to prison for 5 more years. I'm hoping that this is serious enough where you understand that you don't want to mess up again. You don't want to do stupid stuff. You want to try those things, you have to go to the countries where they allow those things. Take a trip. Save some money. $515 or $518 in fines and fees per count. You would be eligible for extended or for earned release programming, substance abuse program, challenge incarceration program. In this initial prison sentence, you won't have time to complete one. I highly encourage you to engage in a treatment program after you're released. You're going to have about 6 months, 5 months, something to sit. And then you're going to be released. I'm going to order as conditions absolute sobriety. No alcohol. You've had history with alcohol. So no alcohol. No illegal substances, drugs, or paraphernalia. Regular testing. No experimenting with creating your own creations. Gainful employment, and that includes your self-employment. You just have to continue to be able to provide for yourself and your kids and all of that. I am going to order that I can't order that you actually do treatment. I can order that you do the evaluation, the assessment for treatment, and you locate a treatment center to be able to do that. I'm hoping that you'll go the next step and you'll actually complete the treatment. Because it says that I think it was 15 is when you first experimented, I think with marijuana, and it was 24 with methamphetamine, if I'm remembering correctly. So yeah, and it's been other things in between until now. Granted, I believe Ms. Chamberlain said this as well as you have said this in one of these documents, that when you were in the relationship with her outliving life, that you stopped consuming alcohol. So that's a positive. Now start on the other things. I'm going to say maybe a mental health evaluation, not because I'm thinking you absolutely need therapy or things like that. Therapy could be great, but perhaps there could be a medication that can give you the clarity. I don't know. I'm not a doctor. I'm not a psychiatrist or anything of that nature. I don't know if you need anything. I don't know if you don't need anything. It's worth just the time that it takes to just meet and be evaluated. Not saying anything's wrong with your brain or anything. You just have to reach out and find what works for you. If it's not Christianity, if it's not Buddhism, if it's not, all of these other things, there are so many other things to try that you, or to look at and to research and, take some philosophy classes, do some of those things to see if you can feel grounded. Instead of deciding to build your own laboratory and create something. You have, I'm not sure the exact amount of dates, I'm sure it's days, but I can find it. 380 days of jail credit. That does include today because you're going to still be in custody for a little bit of time. I'm not going to say no contact with Ms. Chamberlain. It sounds like you guys are going to build your relationship. But I'm sure this is very impactful upon it. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. I'm ordering your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. I believe they probably already have your DNA in the system. So, but that's your call to make. Well, no, not with the Class F. With the Class F, you will not be able to have it expunged. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights restored. I am going to order that upon release from custody that you begin paying your fines and fees at $100 a month. If you are unable to, due to a significant financial hardship, you must motion the court because you're going to be paying here, not to probation. I'm overseeing that, not probation. What that means is if you do not pay, I will issue a warrant and you can sit 6 months in custody for that, consecutive to anything else. Okay? So it's important that you pay. If you can't pay, for some reason, you have to let me know so that we can have a hearing and find out why. Okay? Or so I would probably recommend you pay it off as quickly as you practically can because you don't want me to continue to be riding your back. All right? I think that covers everything, Mr. Schmidt.
Nothing from me.
Ms. Parent.
Nothing for me.
All right. Good luck, Mr. Chaffy.